delighted to have you joined in person. And I understand that there are a number of people online who've had fantastic response to the event. So the event is being live streamed and recorded. After the event, the recording will be uploaded to the YouTube channel with link and slides sent out to attendees. So if anybody doesn't want to be recorded, you have to leave now, basically. We're planning to have food and drinks in the hub downstairs, so please join us if you can. The schedule's designed to last for 90 minutes, and you will hear from activist campaigner Sarah Finch, Stephanie Harrison, King's Counsel, Acland Bryant, Jodie Blackstock. The last three are colleagues from Garden Court's climate justice team. From the event publicity, you may have seen that Paul Clark was supposed to be here this evening. Paul has done remarkable work in recent months, including dedicating hours to the Portuguese students' case, Durarte Agostinho and others against Portugal and 32 states, where the arguments there supported the successful senior Swiss women's case against Switzerland in the European Court of Human Rights. And he also does masses of work as a founding member of the Global Legal Action Network, GLAM. Unfortunately, Paul took a few days off, rare few days off last week, and probably inevitably, he's been floored by a lurgy, and no doubt his body's telling him that he needs to take some rest. So Paul is very disappointed not to be here, but we're very grateful to our colleague Jodie Blackstock, who's agreed at a few hours' notice to stand in and step into his place. So thank you very much, Jodie.
It's a bit of a mad decision.
You won't regret it. Okay, so in terms of the schedule, we're hoping that we will have time at the end for questions as well. But before I introduce Sarah, the first speaker, I just want to thank you and address the delegates. We're privileged that you've joined us tonight in person and online, and the attendees include, perhaps most importantly of all, activists and campaigners who are taking life-changing, at times, risks with their careers, their reputations, their liberty, and even their physical selves. Campaigners putting themselves at the mercy of the authorities in the uncomfortable glare of hostile media publicity to draw attention to the urgency of climate change, biodiversity loss, and the need for a just transition that rapidly changes our way of living so that we can stop trashing our planetary home, and so that there is a fair redistribution of resources shared with our global friends and family, particularly in areas historically and currently exploited. In the room also, there are representatives of NGOs who are crucial for supporting much of the climate justice work which is currently underway, the fruits of which we've started to see. Lots of specialist lawyers pushing the boundaries and looking for the gaps between the solid slabs of law which look immovable, looking for the legal wriggle room to exploit judicial discretion and at the creative application of use of international instruments, judicial decisions from other jurisdictions to leverage out-of-date domestic law favouring the vested interests. And also we've had huge interest from legal academics doing crucial research in this emerging area of climate change law whilst training the next generation of lawyers. A number of other professionals and interested parties, including a couple of architects very much grounded in the physical world and looking for solutions for complex problems in the crucial systems design work that they do. So what we'll be covering? This seminar will cover how to apply recent successful case law in the courts more broadly and imaginatively to protect our precious planet. The topics will include taking on campaign work and litigation, experiences of working with NGOs, tackling injunctions, protecting protest rights and disruption and dissent, and taking inspiration from climate litigation across the globe. So we are, I think, pragmatic realists with forensic dreams to repurpose the machinery of justice so that it runs in harmony with nature, which we are part. And we acknowledge the DNA of our current iterations of the law itself reflects, sadly, socio-economic biases and inequalities. we're working towards establishing entrenching nature-based jurisprudence and legal infrastructure which regulates to assert, ultimately, planetary homeostasis. High ideals and mastery of details are required as we can face these complex, wicked problems that demand a portfolio of responses. So I'm proud and delighted to present our panel of pioneers who, with their energy and determination, their jurisprudential lump hammers and the oily rags, are actively engaged in the nuts and bolts of re-engineering the law. So let's crack on and hear the hot tips on litigating to cool the planet and freeze the assault on nature, building impactful strategic litigation from conception to close. So Sarah Finch. Sarah is a very famous now climate campaigner. Sarah campaigned with the Wheeled Action Group against Surrey County Council's decision to grant planning permission for oil production at Horse Hill in Surrey. She took her climate justice case all the way to the UK Supreme Court and won. And the Supreme Court agreed with Sarah that it was inevitable that greenhouse gas emissions would result from burning of the crude oil produced, potentially to be produced, and that those emissions were clearly indirect effects of the development and the council's failure to assess and to consider the impact of those emissions on the climate and global warming. That the global warming was unlawful. So this groundbreaking judgment will have wide ramifications in the UK and beyond. Sarah was represented by our colleague Mark Willers, KC, of Garden Courts, and supported by NGOs Friends of the Earth and Greenpeace UK. Sarah, the floor is yours.
Thank you. I'm not very intimidated about following your eloquent introduction. I was finding myself really moved by what you were saying. And I'm also intimidated to know that a lot of you are lawyers and experts and probably understand my case even better than I do. So I'm not going to discuss any of the legal aspects or details of its journey through the court. I hope we've got time to discuss that afterwards if people want to. I'm just going to talk about what it felt like for me to be an ordinary person caught up in an increasingly high profile climate case. So also I have to start by saying my name is on the case and it's now the Finch case. So I now share my name with the ruling, but it was never just me doing it. I did it on behalf of the Wheeled Action Group. With the Wheeled Action Group, we chose to have an individual claimant to front it for reasons of Ahu's protection, so I would be protected from adverse costs. But it was always totally a joint group endeavour, and also within that team were our lawyers, so Mark, Garden Court, and our Estelle Tahon Parek from Cornerstone Barristers, and our solicitors at Lee Day, and probably colleagues of yours in your companies that I never met. So thank you everyone, absolutely part of the team, and ditto Friends of the Earth who supported the case really early on. Dave, who's here, used to work at Friends of the Earth, thank you, rang me up like as soon as he heard about it. Well, this sounds like an interesting case. Friends of the Earth due to help enable a tower of strength. So although it says on the judgment Finch versus Surrey County Council, which sounds like a fair, it never was that. So where do we start? Well, this is a historic anniversary. 5 years ago today, the 11th of September 2019, Surrey County Council gave permission for 4 new oil wells to be drilled and 20 years of oil production at Horse Hill in Surrey. We, the Wheeled Action Group, local residents and campaigners had tried to tell them clearly that they should consider the full climate impacts of this development before they gave it ahead. You know, they didn't listen to it, and at the time they didn't listen to us. They gave it permission. We were utterly devastated on that day, but looking back, I think it was a good thing because that's what kicked off our legal case and this 5-year journey that's taken up to this brilliant Supreme Court win and all of the wider implications of that. So thank you, Surrey County Council. So how did the case come about? I have to say it wasn't it felt like a last resort and a bit of a desperate action, a judicial review. We didn't have a theory of change that, oh, we'll look for a planning decision that illustrates some wider point, and then we'll fight it through the courts, and that way we'll bring down the fossil fuel industry. You know, that wasn't how it happened. It was just going to the pub after the planning committee. Well, shit, and what now? Although, so the Wheeled Action Group had previous experience of legal work, and we had fought off a very aggressive injunction. I say we, I had very little to do with that. So Lorraine, who's here, and others fought off an aggressive injunction from the same oil company at Horse Hill, UK Oil and Gas Limited, UCOG. Yes, I strongly represented them on that case. And so when we were facing the big expansion at Horse Hill, I think somebody called up Stephanie and went, oh, can you help us with this one? And she said, talk to Mark. So two of the Wheeled Action Group activists met with Mark, who gave very helpful advice on the kinds of points we should raise with Surrey County Council, so that if they didn't listen to them, could then take to judicial review. So it didn't take very long for us to decide to do that. And then Mark organised a meeting for us with the others who went on to become our legal team. And the meeting was here, not here, it's the other side of, was it this building? Oh, because when I was walking around the square, I thought it was over that side. Anyway, so we came to this meeting, and there was Mark, and there was Estelle de Hon, and there was lots of people from D-Day, and everything went over my head. And the one thing I took away from this meeting is we have to find an individual to front this campaign. So I tried very hard to find an individual. We ran up everybody we could think of. We had this 6-week deadline, time was running out, and in the end I went, okay, I'll just do it then. Which I do not regret, because it's been the most interesting 5-year experience. It's just been such a learning curve I've been on. I mean, the fact that I'm sitting here talking to a whole bunch of people I don't know would be almost unthinkable to me 5 years ago. Some of the things that have come about have just, you know, I've learned so much, and it's been really, really great. So what have I learned about being an individual? Well, a small grassroots group. The Wheeled Action Group is all volunteers, and it's quite a small group of people. We've all got jobs and lives, and you know, so yeah, well, it's showing
a main contribution to it.
Yeah,
Probably several offences you've put.
The first thing that we learned is the law is very expensive. So our initial fundraising target for the judicial review first stage, £35,000, and that was with, you know, reduced fees from the lawyers, Aarhus cost protection, etc. That's like the minimum you're going to have to raise. And then for the appeal court stage, another 30,000. So we in all raised £65,000, which is a very daunting sum when you start out. I mean, it wasn't hard to raise that money, because there were loads of people and organisations that were willing to support us, but it was hard work to give them the opportunities to do so. So we did a crowdfunder, we did music events, we did sponsored events, art events, you name it. Lots of the parish council, CPRE, lots of anti-fracking groups all gave us money. But all of that was a lot of work. Lorraine did a lot of it. You know, she's probably not a person in the whole climate space that hasn't been on her email list. And so, yeah, so it was hard work to earn that £65,000. And I think for many groups, they wouldn't have the reach that we have. And I think that's a barrier to a lot of people taking important action on climate. So I don't know what can be done, but yeah, that was a huge deal. In the end, I think fundraising was a positive part of it, because all those people who gave then felt invested in our campaign, and the support grew. But when we lost in the court appeal and we were considering the Supreme Court, we very nearly just thought we'll leave it here, because we didn't want to go back and for more money again. We thought, like, people have given us generously, they would do again. We can't keep taking money off. And at that point, our solicitors found Law for Change, a funder who offered to pay the cost of that case. So thank you to Law for Change. That was brilliant, and that among some other things sort of enabled us to decide to go ahead. And I hope the Law for Change think they've had good value for that money. I really think they have.
What your costs?
So what else did I learn? It's slow. I initially thought it was going to be about 6 months. As we know, it was nearly, from October 2019 when we sort of initially requested judicial review till June this year. We were a tortuous process. We had 2 judges refused our judicial review. Interesting, they both got the same name, Mrs. Justice Lang and Mrs. Justice Lang. Felt one letter different. Anyway, then we had to go to the Court of Appeal to appeal, can we have our judicial review? And we got that. And that first hearing that happened in November 2020. So that was already a year had gone by. So that was dismissed. So we went to the Court of Appeal, another year's wait to the next hearing. That also dismissed, but split judgment, slightly different grounds, interestingly. And then it was 18 months before the Supreme Court hearing, and then a year to get that result. So meanwhile, we're all getting older and greyer. Fossil fuels are being burnt, carbon's going into the air, the earth is getting warmer, the evidence of the climate impacts are getting worse. It's too slow. We can't fight for 5 years for every paragraph in every problematic bit of law. So another interesting thing for me is the way the case evolved. So the Finch judgment is now famously, in our circles at least, about combustion emissions and whether the emissions from using a fuel are an effect of producing that fuel that have environmental impacts. Turns out they are. Who would have thought it? So it didn't start out that simple. We initially had 5 grounds that we were challenging the decision on. 2 were to do with climate. 1 was actually seismicity. There had been a swarm of earthquakes in the area on the sort of activity of at the site, and there was an absolute whitewash of an inquiry by the Oil and Gas Authority, where they assembled some geologists and told them, said like, well, were these earthquakes caused by oil and gas activities? Don't look at Horse Hill. You can't look at Horse Hill. Nothing was happening there. So these geologists concluded, oh, well, it wasn't to do with oil and gas. Anyway, we thought that was a strong ground. I mean, I think some people thought that was the strongest ground, but as we went through all these various different hearings, that we got whittled away, and it seemed like the combustion emissions one was the one that had the traction. And I'm quite glad of that in retrospect, because it's just so easy to explain. You can explain it to a child or anyone. If you take oil out of the ground in order to burn it, and the greenhouse gas emissions cause climate change, is that an effect of the development? Everybody except for apparently 5 or so judges that agreed with us. So anyway, we won. And then so the next thing I learned is like being in the glare of publicity, which is bizarre. And I have gone from being like a quiet little person whose main form of activism is objecting to planning in my kitchen, to someone that is like invited to speak at meetings like this. I was called a hero by Chris Packen, a big moment, and I got to speak in front of thousands of people in Parliament Square at the Restore Nature Now rally. I have my kids very impressed because their friends are studying my case in their law degrees or their A-level politics. It seems like in the last few months, any kind of magazine I've picked up, there's a picture of me in it. And it's kind of strange, but also quite enjoyable. And main feeling I have is just this gratitude that I was in the time and the place and with the right people to be able to do this thing. And I totally acknowledge my privilege. As Abby has said, the law is actually being used against climate. The law is being used to allow and support fossil fuel production and climate damage, and to harass and silence climate protesters. Here in this country, there's climate protesters in prison serving longer sentences than kind of racist rioters. And in other countries too, of people that, in prison, people even lose their lives. And so sometimes I think like, oh, here's me celebrating a very positive experience of the law. So yeah, really acknowledge that. And I really sort of also feel really gratified by the wider implications of this judgment. So not only is Horse Hill, that planning permission, quashed which is fantastic for everyone that lives around there. But we've seen now much bigger projects with much greater climate impacts. So the government deciding not to defend the Cumbria coal mine and the Rosebank Jackdaw oil and gas fields. Just the other day, there was an oil port development in Northern Ireland stopped, which Acland and Mark worked on, citing my judgment. Acland's just told me about an oil production project off the Falkland Islands, where the developer themselves thought, oh, hold on, we better redo our environmental impact assessment because of this Supreme Court judgment on the other side of the world. I just feel very grateful because as a lifelong environmental campaigner, you don't expect to have such a big impact, and you take a lot of comfort from very small wins usually. You think, oh, well, we've raised awareness of this. We did something very, very small, but we collectively, the Wheeled Action Group, everyone who raised money for us, everyone who gave money, the lawyers who worked, we've actually stopped an appreciable amount of carbon going into the atmosphere. We hope, much worse. Well, obviously those, the coal mine and the North Sea fields are still in the courts because the developers are still fighting those judicial reviews. So yeah, but it seems likely that we've actually have made an appreciable amount. So we've actually made the future a little bit less worse. Every fraction of a degree of climate change we've produced is a good thing. And I feel very sort of grateful to have been able to do this. And I think that everything that everybody does helps, and you never know which is going to be the thing. I never thought the court case was going to be the way that I could have an impact on the world, and it just turned out. So I think everybody has to do whatever they can do. We're at a tipping point now. Perhaps oil and gas production and coal, they are going to reduce rapidly, as they should. And we have to see that the transition is a fair one, and that the people that are impacted by that, the people who currently have a livelihood in fossil fuels in those communities, are the ones that get the training and the opportunities in the renewable energy future. So we all have to do whatever we can to bring on this green transition. And you lawyers are particularly in a unique position. We're going to hear more. I'm really looking forward to hearing what everyone's doing. And yeah, thank you for all that you do, and good luck to everyone.
That was brilliant, Sarah. Thank you very much. But next we will move on to hear from Stephanie Harrison, King's Counsel, colleague at Garden Court Chambers, described as a brilliant advocate.
By my mum.
Not sitting reading notes like I am, that's for sure. Stephanie is a leading public law practitioner who has appeared in all court levels. She has a multidisciplinary practice which spans the breadth of public law and civil liberties. She's regularly involved in test case litigation and has been instrumental in winning some of the most important cases within her areas of specialism in recent times. And it has to put up, as a result, with intense media coverage. Stephanie was appointed as legal counsel to the Equality and Human Rights Commission in 2015 and is ranked for administrative and public law, civil liberties and human rights, as well as immigration, in both the Legal 500 and Chambers UK Bar Guide. The floor is yours, Stephanie.
Thank you very much. So I'm going to start a little bit with the dim and distant past, when I was a little bit in Sarah's position, because my first experience of the law was actually to be the subject of an ex parte interim injunction preventing me and my colleagues at university from protesting against a professor of modern history who was, we thought, beyond the pale in his column in The Sun, writing about racism and writing what we thought was racist and sexist, and all part of the attack on multiculturalism and what now would be called woke. So that's my experience of interim injunctions, and to be subject to them is a daunting thing. And I was fortunate to have a lawyer who came along and not only resisted the injunction, but also defended us in the disciplinary proceedings where I might have failed and been kicked out in my first year at university, and then certainly wouldn't be sitting here now. But what it did do for me is to actually give me an insight into how the law intersects with politics in a most graphic and obvious way, and how what we understood from those proceedings and the legal proceedings was how, in fact, whilst you feel like you're obviously under attack in some respects and adverse consequences can arise, this is an opportunity also to use this other forum, the law and the legal proceedings, to advance and articulate your case, the underlying reason why it is that you've been involved in an activity that's put you against the law, as it were. And I think, and I hope that it's been part of my legal practice, certainly in this field, that when I'm instructed to act on behalf of individuals who find themselves potentially subject to an interim injunction, or they wish to defend against injunctions because they are curtailing their right to free speech and assembly, that one of the motivating features for doing so is that actually this is an opportunity for those people to have another platform for what is the issue that is driving them, and is not just to be seen as undermining and attacking their ability to draw to attention and to raise their voices about the thing that concerns them. And obviously, as we've heard from Sarah, raising our voices and challenging the status quo on the climate and the climate crisis there is nothing more important for people to be doing and to have the space to do that. And certainly, as an overview from my involvement in the cases and that are part of the Wheeled Action Group's litigation, which, as was explained by Sarah, wasn't just about the challenge to the planning decision that allowed for the extraction of fossil fuels in Horse Hill and elsewhere. It was also that there was a wider campaign that was being undertaken by people within that community to resist it. And it seemed to me it would be sensible to resist it on all fronts, whether that's in the court because they were going to be subject to an injunction, or in respect of the underlying issue, the planning permission itself. So having a wider sense of what opportunity legal proceedings might bring, as well as the challenges that they face, I think is an important part of being a lawyer who's not just interested in the law and the rights, but also in the underlying issues, that you can facilitate to some extent the ability of those groups to raise the profile of the issue. And I think one of the things that I find very disturbing is that we have seen in the last 2 or 3 years the most draconian attack on the ability to protest through legislation that's unprecedented in its undermining and cutting across of this fundamental right. The legal space for lawful protest is now seriously curtailed by the 2 pieces of legislation that the last Tory government introduced, and in its most extreme form, banning noisy protest. If a protest is noisy, it's not a protest, is it? Unless you want to do a silent visual. But the extent to which the right itself has been curtailed and undermined is extraordinary, and it has brought to the attention of the Special Rapporteur on free speech and assembly at an international level that the United Kingdom is taking steps that are seen as completely out of step with the core principles underlying the convention, and what we would also have said, at least until recently, what our own common law traditions provide. So we are in a context in which there has been the most serious assault on the ability of individuals to exercise this right. And it's in a context of 2 forms of protest in particular. One is the one that we're talking about, which is about environmental protests and climate crisis, but also the protests that arose out of the death of George Floyd in the United States, and what that said about structural racism, both within the United States and across the globe. So those are the 2 issues that have led to another justification for the most draconian reduction in our ability freely to engage in free speech and assembly. And one has to step back and wonder how that possibly could be the case, because if there are 2 issues that are the issues of our time that need to be addressed and can't simply be ignored. It is the climate crisis and the call, long overdue and essential for the operation of a civilized society, racial justice. So for me, can't abstract the law from the protest and the concerns of the people who are raising their voices, and they're not incidental. If you look at the court will say, well, we're not interested in the legitimacy of the campaign and its concerns. That's not what we're here to adjudicate on, but that would be wrong, because although the court is not going to say this is a good or a bad protest, that doesn't matter. It is going to have to address the fact that they're dealing with individuals who have a more than legitimate concern and entirely meritorious reason why they're engaging in the protest activity and civil disobedience that, as we know, has a long history in the UK. So for me, the content, the reason why people are engaged in these activities is a critical part of what needs to go into the legal case. And that's certainly what we did in the context of the defending civil injunctions in the wheeled action case. It was part of a series of cases that were brought by companies engaged in fracking and other forms of unconventional extraction of fossil fuels. They had sought in 2017 essentially to have a nationwide ban on protest and restriction on protest against fracking. And we are going to go now. I'm having slides of mine. I just need to go to, yeah. So, and they did it through this very unorthodox route. So they did it through what's called persons unknown injunctions. So whilst there's always been in principle the ability of a case to be brought without a named person, it was an exceptional jurisdiction, and it only occurred in very limited circumstances. But what happened in 2017, in particular with the INEOS case, which was the first one, was that fracking companies, Mr. Radcliffe, with his vast sums of money, decided that he would resort to the civil law to restrict the protests that were taking place, in particular in his site, in sites that he had purchased, based on what was happening in the Quadrilla site in the northwest of England. And he had decided, INEOS had decided to use the civil law because they were unhappy with the way in which criminal law defined what was lawful protest. But then it wasn't working because the criminal law at that time was facilitating protests that they thought was unacceptable and disruptive. And it's clear from the evidence, and they said it in terms, we are coming to the civil court in order to, because the forms of protest that are being permitted causes too much economic damage and disruption, and also the police are not doing enough to do it. So they were making what is in fact quite an extreme statement. They were not happy about the way that the criminal law operates, and they wanted to subvert it because they had the resources and the means to do so by bringing civil claims, because they have civil injunctions, because they have very deep pockets. They have no concerns, unlike what you've heard from Sarah about the cost risks for them. They had infinite amounts of money, and they had a large legal team to go without notice. That's where only they go to court and ask the judge for an order. And they were able to obtain an order against a person unknown, against persons unknown. No individual needed to be named in these proceedings. And they got the most wide-ranging injunction that prevented protest at sites, some of which they hadn't even started to work on, but were across the whole country. And the draconian elements of the injunction were not just its scope, but precisely because they were against persons unknown. So in normal legal proceedings, you make a claim against a named person that they have done something wrong, and you come to your court with evidence to prove that they've done something wrong, and then the court can decide whether or not it's appropriate to take any steps to curtail their rights and to to do that. And of course, if you've got if you have a named person, you have an opponent who's going to advance their own rights and put the alternative case. All of that was set aside when they chose to use proceedings against persons unknown, because whilst it's an order that's against nobody, but then also against everybody, because the real vice of a persons unknown injunction, this was the kind of injunction that was being sought by UCOG as well as INEOS, was that you are bound by an order, even though you've never paid any part in the order being made. So you've never had an opportunity to put your case to say, well, actually, this is to go too far. It's going to interfere with my rights to free speech and assembly. What we're doing is perfectly legitimate, etc. That's never happened. But nevertheless, if you were then to take part in a protest that was found to breach the order, then you would automatically be at risk of being found to have acting in contempt. And contempt is the way in which civil injunctions are enforced, and they are proceedings that can result in 2 years imprisonment and unlimited fines. And at the point at which these orders were being sought, the very idea that a person might go to prison for participating in lawful activity, or peaceful protest, was remote, because that wasn't what was understood to be the likely outcome. Circumstances are very different now, but it was very shocking to think they're using this process in order to be able to increase the penalties. If the similar action, if you were in the magistrate's court, if you were convicted at all, would not be attracting either a risk of a criminal penalty and or very substantial fines, as well as paying the costs of the privilege of being subject to one of these injunctions and being found in breach of it. So this form of injunction is extremely draconian. It puts all the tools, or all the power in the hands of potentially of the powerful private companies like INEOS and others, and does leave individuals who wish to seek it with many disadvantages, both procedurally and practically, because you don't have the resources, you can't take the risk of large costs, orders against you. The costs that INEOS sought were close to £1 million for the proceedings when it concluded. Fortunately, they had to pay our costs in the end, but their costs were close to £1 million. So you can just see the extent of the pressure that would put on any person. But what I would say is that despite all of those challenges that they face, having motivated people who were prepared to stand up and say, well, actually, we will put our head above the parapet and we will actually seek to defend this injunction, meant that over time, through this case law that you see there, we were able to limit the extent to which persons unknown injunctions could be imposed. We haven't succeeded, as we hope to do so, to say they're impermissible, because they don't have a proper statutory base and they are unfair, fundamentally unfair. The case that you see there was the most recent case, it's a Wolverhampton case that went to the Supreme Court and did it. We were challenged to say you can't have these injunctions in principle. Supreme Court said you can, because equity, that ancient remedy, will provide you with the means to implement these things. However, we have put very substantial limitations on when an injunction such as this can be achieved. That's benefited firstly because the case was a gypsy and traveller case, but also protest cases. It's correct that Friends of the Earth played a very important role in continuing to pursue that issue. And the issue of whether in principle you could have such an injunction is going to Strasbourg. So we hope that we will be able to make some further progress with challenging whether in principle these orders can be made. In the end, it's a battle as to testing out whether they've met the criteria, and those criteria involve demonstrating that you can't in fact identify wrongdoers, people who've committed, who you can allege have done something that is unlawful. And there's no alternative to that, as well as ensuring that any terms of an injunction that are imposed in these terms are very clear and obvious and people understand. exactly what it is that they're not supposed to do, given that they weren't in the proceedings when the order was made, and that they have very clear geographical and temporal limits. So it's an amelioration of something that is draconian, but that would not have happened without individuals like Lorraine and her colleagues at Action being prepared to put their head above the parapet. We were only, however, able to do it because we managed to persuade UCOG, for reasons that are not quite clear, but they're probably not good ones, to agree that they wouldn't seek their costs against us. That has some benefits, which is you can pursue the case and you don't have the cost risks in the UCOG context. But it does mean that they've got unlimited action. No, they've got no cost risks either, and they can fight cases even when it's hopeless. But what was important ultimately about the UCOG case, it took us 3 years before we actually got it overturned and very severely curtailed. And they started off with persons unknown. That's the whole world. They then, after having to demonstrate that they could bring a case against individuals, because they always could, they then identified 100 people who they said were involved in activity that was unlawful, which we then challenged. And by the end of the case, they had 5 people who they said they were able to identify had done something that was wrong. But that in itself illustrates how you can have orders that capture and make potentially liable for very serious penalties a whole range of people, whether or not they've done anything wrong, and whether a case could be proved against them. And so the process of being involved in that case did illustrate just how pernicious this form of order is. The only thing that I would say is that that can't be done in every case, because there aren't people who are willing and able to do that. And what you see, one of the things I asked our researcher today was, have a look and tell me how many persons unknown injunctions have been granted in 2024. And she said to me, well, it's going to be, it'll probably be up 4 or 5. It won't be a big job, will it? And I'm going, no, I don't think it'll be a big job. It is a huge and enormous list of cases where persons unknown injunctions have been granted, including 12 in respect of Just Stop Oil actions against airports. So whilst it's part of the purpose of this meeting to be positive and to say, look, we can do something and we must challenge it, and we ought to do it because it is a platform in which we can also raise the issue, we have to be realistic and understand that the use of civil injunctions is now perhaps one of the most potent tools that the state is using to curtail protest, because in the vast majority of those cases, there was no individual to defend it. There was no NGO that was able to stand up and say, well, we want to make some submissions. We want to challenge this case. And that's the reality of the situation, that you will have large numbers of cases where there was no challenge whatsoever, and the companies were able effectively on the nod to get these orders. So it's not a positive story in the end. What's positive is to say that where you do have the ability and the willingness of people to stand up, then we can do something. But we can't expect that to be in every case, because people can't spend their whole lives involved in litigation, and they can't be always willing to take the risks. But if you do wish to do so, then with realistic advice and in appropriate circumstances, then I would encourage people to think about doing that.
Thank you. So whilst Acland sorts himself out, I'm going to introduce Acland. He's called to the Bar of Northern Ireland as well as to England and Wales, and is developing very quickly a broad practice in administrative and public law, specialising in environmental law and climate justice. He has expertise in all areas of domestic and international environmental law, working with international environmental NGOs, charities, activists, and individuals impacted by environmental degradation and climate change. He has significant experience in planning law, particularly in assessing the environmental and climate impacts of planning applications. Acland has previously done the role of parish councillor and involved in considering planning applications affecting his parish and its residents, along with enforcement applications and appeals. His practice also extends to planning inquiries and public law challenges to planning decisions. Prior to joining Garden Courts, Acland was a lawyer at Friends of the Earth and has worked on several high-profile judicial reviews. In his spare time, alongside his practice at Garden Court, Acland is a doctoral candidate undertaking research in climate litigation and an associate tutor at the University of East Anglia. And finally, only this week, Acland had a fantastic result in Northern Ireland, acting for the Stop Whitehead Oil Terminal campaign, instructed by PILS, the Public Interest Litigation Support Project of Northern Ireland. Over to you.
Great. Sorry to stand up and look formal. I'm afraid I don't have my notes with me and my eyesight's not good enough to see the screen, so I've got to stand up. But my presentation is essentially on experiences of working with an NGO. And because I've volunteered for NGOs in the past, I've worked for NGOs and I've represented them, hopefully I can provide a useful overview of working with an NGO. I think a great place to start is how judges have received NGOs, what they've said about them. And Lady Hale, our former president of the Supreme Court, in her speech in 2013, made a number of points about NGOs and the importance of them. So she, in summary, said that they contribute to the enforcement of the law, protection of human rights, they hold governments to account, ensure public bodies act within the law, they're essential for maintaining the rule of law, and they present arguments or material that others may not otherwise do so within the cases. So they play a really important role within our society, and particularly within the environment and climate litigation space. The LSE Global Trends in Climate Litigation Report 2024 said that in 2023, more than 70% of all cases were brought by individuals or non-governmental organisations. And some of those cases are obviously brought together, some are just brought by individuals, some by NGOs, but it gives an idea of how active the NGOs are within this sector. So what can an NGO bring to a challenge? And I think everyone thinks about interventions, but it's actually much wider than that. They can provide guidance and support. So if you approach them at the beginning of a case, they can point you in the direction of experts, they can talk to you about the legal issues. And as Sarah said, many of these cases are extremely daunting. They can provide you with that reassurance. They provide education and training to community groups and can provide insight into their local issues. They can provide advocacy policy and campaigning support. So taking those issues and making them a really big public interest matter, raising public awareness, putting these issues on everyone's radar. They can provide research, expertise and insights. And there are a number of cases where NGOs have provided written evidence or their own in-house research, which has been instrumental to challenging the cases. To give an example, many of these massive planning applications have highly technical reports and environmental impact assessments. NGOs, for example, RSPB, they can provide a witness statement or report on the impact of birds that can be extremely helpful in litigation. They can provide funding towards cases, fundraising support, so helping communities access crowd justice or GoFundMe, and they can provide legal representation, advice or assistance. And of course, all of this depends on each NGO. Every NGO is different, every NGO has their own identity and can help in different ways. So not every NGO can provide all of these services, but certainly some can provide some and others can provide others. So don't need to read all the cases, but ways of litigating with an NGO. We have cases where NGOs take the lead. So the two cases there are the Friends of the Earth, Climate Earth Good Law Project case against the Carbon Budget Delivery Plan, which found that our current strategy for net zero was unlawful. It was a very successful case. We have Greenpeace and Uplift, who have been challenging offshore oil and gas licensing, and they've had a big success recently in respect of Rosebank, where following Finch, they conceded a case. We have co-claimant cases, so cases where NGOs and either local community groups or individuals act as one. They have the same legal team. An example is the No Gas Caverns case in Northern Ireland, where the local community group, No Gas Caverns and Friends of the Earth, took a joint case and were successful in the Court of Appeal. We have cases where NGOs intervene and they can provide a new perspective on the particular legal issues. An obvious example is the Finch case. I had to mention that with Sarah here tonight. But equally, there are amicus curiae interventions, such as in the ITLOS advisory opinion, and many NGOs, including Opportunity Green, for example, provided their own submissions. And then there are cases where NGOs provide litigation support. So they might not actively be involved in the case, they might not have a voice making their own representations, but they can provide support nonetheless. So in the matter of an application for judicial review by Claudia Miscali, that's the Northern Ireland case I was involved in earlier this week, the Public Interest Litigation Support Service provided a solicitor who could act on behalf of the claimants to bring the case, so they didn't have to incur those legal fees. They provided counsel from their pro bono register so that they didn't have to pay barristers to provide advice and representation, and they assisted with funding the cost of making the application for judicial review. Another example is the Solicitor General and Trudy Warner case, where Good Law Project provided significant support to Trudy Warner, who was being prosecuted for protesting outside the courts. So there's lots of ways that individuals, campaign groups can work with NGOs. So what might an individual need to consider before approaching an NGO? Well, the first question I think is, what kind of litigation support do I need or would really help me in my case? Is it advocacy and campaigning work? Is it communications? Is it legal advice? Is it representation? That would be the first question I would ask myself if I was taking a case, because that influences which NGOs I may then go and approach. Which is the next question. Who are the NGOs that can assist me? As I said, every NGO has different characteristics, different ways they can support. So you need to do your research before approaching NGOs. You need to understand what they can realistically do and what they can't do to assist you. When should I approach an NGO? And I'm going to give a typical lawyer answer and say it depends. It really does depend, though. It depends on your case and what you want. If you are looking for a co-claimant, you need to be going to them at the earliest opportunity, because we have to remember, in judicial review claims, we have a very tight time period of 3 months. And in planning, it can be even shorter, 6 weeks. And NGOs have to get on board, they have to look at the matter, they have to go through their internal processes, get outside counsel. So there's lots for them to do. And if you approach them on a day or two before the filing deadline, it's never going to happen. So if you're looking for that kind of support, you need to be in early. If you're looking for someone who wants to intervene, you can approach them anywhere you want in time during that litigation process. But again, the earlier you get them involved, I feel, the more you can start to benefit from all they can bring to the table. So what might an NGO consider? So you've got your case, you've taken it to an NGO, they're not automatically going to get on board, I'm afraid to say. So some of the things that NGOs consider when they're approached by individuals or local community groups are things like strategic alignment. Every NGO has strategies, things that they're trying to achieve. So if your case doesn't align with their strategy, it might be that they are not able to put their resources into your case. Other things are organizational priorities. So even if you've got that strategic alignment, you are bringing an oil and gas challenge, and this is an NGO that has a focus on oil and gas, they may have other cases, other campaigns, other priorities that mean that they can't assist. Or they may see this as a really great opportunity to get involved and to share and give a voice and some support. Next is capacity. So NGOs, again, are not huge organizations, they vary in size. And so some have very small legal teams. And we have to recognize that if they've got a number of cases ongoing, they can't always jump on board with everyone else's case. Timing we've touched on. So like I said, if you bring a case to them the day before the filing deadline, you're going to probably get a no from them. So think very carefully about when you approach an NGO. And the last is costs. NGOs have finite resources. They cannot fund every single case that comes their way. And so we have to be realistic about how much an NGO can provide us with support and also what kind of support they can provide. So I'm now going to talk about two issues that I think are relevant both to individuals, local community groups, and to NGOs. The first issue, which is a legal issue, is standing. And there are two cases that I want to talk about that are both 2024 cases that I think should be on everyone's radar because they have an impact on standing. So the first is the Mussington case, and not everyone may be familiar with this. This is a Privy Council case. It comes from the Caribbean islands, the island of Barbuda. And so it's not a traditional case that one might look at if you're operating in England and Wales. But it's highly relevant because actually what it really grapples with is standing and applies common law principles and cites a lot of UK cases. So within that case itself, the judgment talks about previous Supreme Court decisions, the the Good Law Project's case on standing, the Duff case on standing for Northern Ireland, and draws a lot of those principles together. And in that case, what the court was concerned with was an airport or the planning permission for an airport on the island of Barbuda, and two local residents sought to challenge the planning permission. And the court found that these two local residents who had been turned down, been told they don't have standing in both the High Court and the Court of Appeal, were told that they did have standing, and there were essentially three ways that the Privy Council identified these two applicants had standing. The first is geographically. So they lived so close to the airport runway, they were virtually at the end of the runway. The court said, well, how can they not have standing? How can they not be able to speak to this project when the planes are virtually just missing their house at the end of the runway? The second is the failure to follow due process. They essentially started clearing the land and building the runway even though they didn't have full planning permission. And so they said there was issues around public importance, the duty of candour, that meant that these people should be able to bring those matters to court. And then lastly, which is a key consideration for those of us who are interested in environment and climate, they demonstrated some knowledge or concern for the subject. And we're talking about the flora, fauna, and environment as a whole. And I think that phrase, some knowledge or concern, is a really interesting phrase because it's different to the phrase of sufficient interest, which we may all be used to in other cases. This hasn't been tested in court yet. We don't know what some concern precisely means, but I have a feeling that it may be a slightly lower test. In my eyes, it's a slightly lower test for standing and a move towards giving more people a voice in these sorts of claims. But we have to remember that each case turns on its facts, and so we cannot say for definite whether this has changed or moved the test for standing, but certainly I would expect this to be a case cited in future cases brought by individuals. The next is the Klima Signorin case, which is a really, really big case this year in the European Court of Human Rights. And there were some really, really interesting things said in that case about associations and standing. That's completely changed our view of what associations and NGOs and other groups can and can't speak to. So I put a couple of big quotes on there. Remember, you will get the slides afterwards, so don't rush to read it and jot it down. You will get all the material. But essentially what the court did was it looked at climate change as a subject. And considering climate change as a whole, its importance, how widely it affects people, the court was saying that those individuals need to have a voice, not just in and of themselves, but be able to be represented by groups. And we can see in 499, they're talking about the special feature of climate change as a common concern for humans. This is really broad brush language from the court. It's really widening the scope of standing in my view. But, and there's a but there, the court laid down principles. And again, I know there's a lot of text there. Again, you'll get the slides. They lay down principles that are going to be applied in future cases. And so, A, we're looking at this association or NGO needs to be lawfully established in their own jurisdiction. B, they need to be able to demonstrate that they have a dedicated purpose, and part of that purpose or objective is the defence of human rights. C, they need to be able to demonstrate that they have a genuine and qualified ability to represent and act on behalf of members of the public and community. But in theory, associations and NGOs can start to bring human rights cases. And that's always been an area that NGOs have generally shied away from, opting instead to support individuals in bringing cases or acting as co-claimant with individuals. This case potentially widens that scope and allows NGOs to bring cases even when there's not an identifiable individual. So this is a really key case for NGOs to consider. The next issue I'm going to move on to is Aarhus and cost protection. So Aarhus provides cost protection in certain types of claims. There's a full definition within the Aarhus Convention, but essentially we're talking about judicial review cases that fall within the scope of the convention. Again, there's certain specifics there, but the case has to relate to either an access to environmental information and or environmental justice. And what environmental justice means seems to be three different things. Either there's elements of the environment which are concerned, there are factors affecting the environment, and or there's some form of social environment, and that's in Article 2.3. But a slight word of warning, whilst those factors seem extremely broad, and you would think you can bring in all manner of environmental cases, cases in this jurisdiction have said it's not all that wide. So Client Earth and FCA case, Lang J held that the Aarhus cost protection cap didn't apply because whilst they had environmental concerns, the key nub of the case, what was the key issue, related to financial or not environmental. So we have to be careful. We have to recognise that Aarhus in this jurisdiction at least has its limits. But if we do establish an Aarhus claim, if it falls within the definition of an Aarhus claim, then what that means is that there are default cost limits that can be applied. Those cost limits are inclusive of that. So the Friends of the Earth case established that, and the cost capping for individuals is £5,000. For legal entities and unincorporated associations, 10,000, and for the respondents, which are generally governmental departments, £35,000. What that means is if you lose, the cost you have to pay the other side are capped at that figure. So if I'm an individual bringing a case and I lost my case, the maximum amount I would have to pay the government or the other side is £5,000. Equally, if I'm an individual and I win my case, the maximum I can recover from the government is £35,000. None of this affects my individual legal fees. So that's a really important matter. So my legal fees are £20,000 and I lose, I've still got to pay my £20,000 legal bill plus the £5,000 adverse cost. So there is the Aarhus cost capping is really, really beneficial, but it has its limits as well. There is the ability to amend or apply to amend the adverse cost cap. So I've got the RSPB case there that you can go and look, but essentially you can apply to shift the defendant's Aarhus cost cap up. So for example, ask for the court to impose a £50,000 adverse cost cap, so you could recover up to £50,000. Equally, you can ask to lower your cost cap, but if you're going to go down that route, you firstly need to make sure you're providing solid evidence to support your application to shift the cost cap, which means witness evidence as well as financial evidence to show the court why you are asking, what your financial means are. And generally, very few people go down that route, and there's been limited success, but there is potential there to shift the cost cap if needs be. That's the end of my presentation, so thank you very much for listening.
So thank you, Acland. And we turn now to Jodie Blackstock. The floor will be yours in a minute. Jodie was called to the bar of Trinidad and Tobago, as well as England and Wales. She was the legal director of the organisation Justice for 5 years before joining Chambers, during which time She built inter alia expertise in relation to EU law. Jodie takes judicial review proceedings and civil actions, including against criminal justice actors, and she has also taken a number of constitutional and judicial review matters in the Caribbean and on appeal to the Privy Council. She has advised and acted in third-party interventions for NGOs in a number of jurisdictions, and she is also, in her spare time, Treasurer of the Bar Human Rights Committee, with which she has undertaken training programmes, trial observations, drafted statements on human rights abuses across the globe. Over to you.
Thank you. I'm going to stay here because otherwise I'm going to climb over everyone. I'm also conscious of the time, and there may be some burning questions from this audience of experts in the room. So I'm just going to take you through a series of what I would say are sort of questions or bullet points around starting this kind of case from my perspective, taking a case study that I'm working on at the moment in Trinidad. And the Finch case that Sarah's told us about, the Finch case, I'm doing it. Yeah, the Finch case right here gives us a great sort of platform that you started to tell us about, which is travelling around the UK now and perhaps is stopping things happening in this jurisdiction. But that doesn't mean that the oil and gas companies are going to give up the fight. It means that they're moving to the global south to continue the work there. And they're positioning themselves, particularly on gas, as the transition energy to net zero. In Trinidad and Tobago, the problem comes from Shell. And Shell's energy transition strategy for 2024 says that LNG will play a critical role in the energy transition, replacing coal in heavy industry. It has a continued role in the displacement of coal in power generation, helping to reduce local air pollution and carbon emissions. LNG helps to provide the flexibility the power system needs at a time when renewable energy is growing. In its LNG outlook, also for this year, it suggests that the global demand for LNG is estimated to rise by more than 50% by 2040, as industrial coal to gas switching gathers pace in China, South Asia, Southeastern Asian countries in particular. And these countries are expected to use more LNG to support their economic growth. So great, Shell is getting on the bandwagon and telling all of the developing nations of the world, this is the way forwards. Unfortunately for a country like Trinidad and Tobago and developing countries, particularly across the Caribbean, these are states which obviously have not contributed to the climate crisis, and they believe they've got a carbon budget to spend. They also think that these are deals which are going to bring lots of money into the country. So the political rhetoric in Trinidad is about how great these deals are and how they will provide energy security for many years to come. I'm looking at the Dragon deal and the Manatee deal. The Dragon deal is with Venezuela, which was obviously put on hold for a while because of sanctions, but the US government has lifted those sanctions in relation to this deal because it also wants some of the gas. That's off the west coast of Trinidad. There is 4.2 trillion cubic feet of gas to play with there. The Manatee deal is off the southeast coast of Trinidad, also shared with Venezuela, but they're doing their deals separately on this case. So in this one, I can't really argue human rights, socio-economic, despotic regime, sanctions. But there's 10 trillion cubic feet of gas to play with in this one, of which Trinidad has a portion. So what am I looking at doing? I've got 9 points on my list at the moment. They're not necessarily in order, and they won't necessarily get to use all of them, but taking them in the order that come to me while sat here typing away my presentation. Firstly, I'm going to challenge the state, not Shell, because companies, obviously, as we've heard about from Stephanie, a huge amount of money. The Aarhus Convention doesn't apply in Trinidad and Tobago. So bringing the case against the state and challenging what they've done to allow this deal to take place is a less cost risk to the case. That means we're looking at public law and statutory obligations on the state, and possibly making human rights claims post the Swiss grannies if we can find a route to do that. So I'm asking myself, which of those is the strongest route? At the moment, they're potentially all to play with. Secondly, time limits. Start early, monitor the problem, choose your moment to bring the case. And remember, if you're taking a JR, you've only got 3 months. So from the point when a decision is made that you think you can challenge, you've got to move very quickly. In this case, there are stops and starts. And so there are parts that I've already missed, unfortunately, but Shell on the Manatee deal has just agreed to make its financial contribution. That means it's going ahead. So that gives us the opportunity to start the ball rolling on that one. On the Dragon deal, there isn't an environmental impact assessment yet. So although government says deal's amazing, we're cracking on with it, it's actually still fairly early days in terms of the challenge. Third, political criticism. I need to get opposition MPs on the floor of the House in Parliament asking the right questions to challenge these deals. At the moment, they're asking questions about why we're doing a deal with Venezuela. Nobody is raising, should we be producing these emissions when we could actually produce our energy self-sufficiently from the abundance of sun, wind, and tidal power that we have available to us. So I need to have those conversations, get the questions to be asked. And the benefit of that is you start to create an environment in which the reasonableness of decisions taken by government can be viewed in a judicial context against the Hansard background. If there's lots of questions being asked critically in Parliament, the reasonableness of the decision starts to become less sound. 4, local engagement and clients. I obviously can't do this on my own. We're very lucky at my firm in Trinidad that we can use people who have interest to bring these cases forward, particularly connected to the opposition party. But in a case like this, I really want it to be local people who are directly affected. And there are numbers of community groups in the country that I'm sure would be happy to put their name to this, a bit like Sarah did. 4th, and I suppose, yeah, so it will be 5th next, but just finishing up on 4th, NGOs comes in on that. And together with 5, expert evidence on the local science and environmental conditions. Clients can be NGOs, but they can also be experts. So straddling my 4 and 5, I need the local NGOs to tell me what they think about this issue and what they've been doing about it on the ground. 6, awareness. I also want a media campaign on the issue ahead of the case starting, because again, if we start to get criticism, not just in Parliament, but in the court of public opinion, you can start to unravel the benefits of bringing this kind of project to fruition. The more challenge there is to it, the more unlikely government is going to want to stick with it. 7, obtain the environmental impact assessment. In Trinidad and Tobago, these are not published on the website. It's a long list of what they've done, but you can't actually access the document. I now need to make a Freedom of Information Act request to get that. I have a Dragon deal case already going to the Privy Council next year because they've refused to give us any documents in the deal so far. So Privy Council is going to give us some hopefully helpful dicta on what public interest means in that case, which I can then utilise when it comes back round, because they always go to Privy Council on the actual content of the deal. When looking at the environmental impact assessment, I'm going to want to look at, does it assess scientific and international updates, agreements and case law that have arisen since the last one that they provided for a fossil fuel project. So I obviously need to know what they are, and I need to argue that they should be followed domestically in this jurisdiction. So I'm looking at which are the most persuasive countries to use in that. Obviously, Supreme Court from the UK is effectively the Privy Council. It's the same judges. So that really helps me. But if there's any cases from Canada, the judges in Trinidad love Canadian cases. So I want some of those to help me domestically before we get to Privy Council if I can. Obviously, we've had a number of regional and international cases, the Strasbourg cases, the Inter-American Advisory Opinions coming, and the ITLOS decision on marine pollution is incredibly helpful for this, because I'm talking about offshore sea development, right? And that case really emphasises that human-made greenhouse gas emissions are a marine pollutant, and that there is a stringent obligation on contracting states to the International Convention on the Law of the Sea to prevent and reduce those pollutants. Query extracting trillions of cubic feet of gas might come up against those obligations. But Trinidad, like the UK, is a dualist country. So how persuasive is the decision of that international tribunal domestically? These decisions are helpful and persuasive, but they are not binding. Also, the EIA, does it follow all the requirements under the domestic legislation? And how do you interpret that? So this is where the Finch decision comes in as a helpful barometer on what do we mean by emissions. Have they incorporated the downstream emissions? Have they done a public consultation? Because I haven't heard of one, but that's in the legislation that they're required to hold that as part of their process. So there's a lot I need to get out of that EIA when I finally get hold of it, if I get hold of it. Number 8, consider financing. Is this sufficient for the project to go ahead? How much will it cost the country? Has the national budget factored this in? Will it lead to stranded assets? These arrangements cost the local country a huge amount of money annually before any fuels are, well, oil, gas, coal, whatever it is, are extracted. In a country that's developing like Trinidad and Tobago, is it really worth having to spend millions of dollars before you get anything out of it, particularly when there's a risk that those assets will be stranded and the project will have to stop because of our climate commitments and because Venezuela is crazy at the moment. 9, finally, consider the risks. Is the insurance comprehensive enough for the risks of leaks and damage? You were talking about seismic issues in your case, which were not taken forward in the end. But offshore drilling, seismic activity, sea's not flat, all sorts of things going on down there, particularly in that region, tsunami from drilling, oil and gas leaks which can spread across the ocean floor, destroying everything. How much must the government underwrite against those risks? Can they really properly underwrite it? A colleague of mine in Guyana, who's taking these challenges against Exxon, doing a very similar thing down there, has successfully won a case on the paucity insurance that the government put forward to underwrite those risks, because she was able to demonstrate with experts a spill on a deep sea drill can travel, this is oil rather than gas, across the whole of the Caribbean Sea all the way to Jamaica. That's destruction on a massive scale. In the context of Trinidad and Tobago, there was an oil tanker from Venezuela off the coast of Tobago for about a month earlier in the summer, spilling oil. It has effectively destroyed the marine environment off the coast of Tobago. They say it's cleaned up, but it's not, because you can never clean up oil. On the surface, it's no longer visible, but below, it's a massive problem. That's the country that they're proposing to do a deal with. That was oil on its way to Guyana. Also, recently, in the last couple of years, 2 years ago in Trinidad, divers went down to inspect a leak off one of the oil pipes. Went in, inadequate safety provision with that dive, and all 4 of them died in the pipe. They got into difficulty, they communicated their difficulty, no one went to help. My colleagues in my firm in Trinidad were involved in the inquiry there, and it was absolutely scathing. So there are human risks and there are environmental risks. Can we really underwrite them sufficiently? So that's what's on my agenda. And yes, I might have to add other points to the list as I go along, but that's what, for me, are the kinds of questions we need to think about when we are creatively starting to tackle the next big proposed project. Thanks.
Well, thank you very much. We were down to finish for 7:30. I think it's 29 minutes past, but we started late. So does anybody have any burning questions?
Hello. Firstly, I'm a law student. I just wanted to say what fantastic work you all are doing, and Mark as well, to kind of inspire the next generation of potential lawyers to look at working in public interest versus the traditional pipeline of going straight into magic and, you know, slave soul. My question regards the OEP, and I was wondering, as a kind of not exactly an NGO, more kind of public body, what experience you've had working with the OEP, how you can leverage their kind of role in future litigation, and when they do make submissions, how valued they are by the courts, and yeah, what role they play in the future.
So take some of that, but Sarah, I don't know if you want to take some of that because they were involved in.
Well, I could just say quickly that they intervened in my case, and they did at the Supreme Court stage, and they did say they were neutral, they weren't sort of on either side, but their intervention was helpful. The Supreme Court actually specifically thanked them and said that their intervention was particularly helpful. So obviously it's influential. And I'd also say they have a webinar on the 31st of October on my case, which is weirdly called Life After Finch. Okay. It's on the 31st of October, so that's specifically about my case, so that might be interesting. That's all I could say.
So my experience with the OEP is in the Finch case, kind of seeing their involvement there to start off with, but they've also been active outside of Finch. Finch is their only actual litigation case they've taken so far. But they've been very active recently in Northern Ireland, for example, in relation to ammonia as an issue that they've got over there. And quite often it seems to be when the OEP are saying you need to take urgent action, otherwise we will take further action, governmental departments are conceding and backing down. What we haven't yet seen is the OEP use its power of environmental review, which is its own specific power to bring essentially a judicial review within which they have standing. So there are powers yet from the OEP we have not yet seen, which will be really, really interesting to see when that is used and how it is used. But at the moment, they seem to be working really actively in this sector. But we have to remember that, again, the OEP has limitations. It cannot investigate every form of environmental harm, every form of environmental damage. And the OEP is very clear in that it has its own strategic objectives, the things that it is focusing. So we have to remember the OEP is not going to resolve everything, at least not initially, but they seem to be at the moment a force for good.
Brilliant. Thank you. Anyone else have a burning question?
I have one for Stephanie. Do you expect the rise in the use of Section 7 and the other public order offences to be on the use of injunctions? Do you think injunctions are going to die a death? Because at Drax, for example, which is effectively private land, people are being charged with Section 7 offences and with public order offences. So do you think that the use of injunctions will end eventually?
I think that what you can see over time is that there has been a kind of symbiotic relationship between the criminal law and the use of civil injunctions. So as I explained about the INEOS and the anti-fracking protests, what we're seeing then is we'll use the civil law because we don't think the criminal law is working. Obviously, we've seen this vast amount of legislation, but the case law so far doesn't look like the companies are not using that technique as well. They seem to be doing it in parallel, and certainly one of the cases was a Drax case. So they did have injunction proceedings as well.
I was more wondering what the reaction of the judges would be to say that you don't need to use injunctions anymore because you've got this raft of
measures. Well, one of the main arguments that we sought to use was exactly that. Well, why is it that you are using civil injunctions that are in equity, that they're not clearly defined, Parliament hasn't defined what's right and what's wrong. It doesn't have the level of clarity and certainty that's necessary to meet the convention obligations, and there's a fundamental anti-democratic element to it because it hasn't been passed through Parliament, and then you've got a judge, and they were bringing the proceedings in the Chancery Division, the judges who spend most of their lives dealing with finance and commercial activity, and obviously we're likely to be thinking in favour of those who as commercial activities might be being affected by the protests. So that was exactly the argument that was being run, and we were using case law, a case called Laporte, where Lord Bingham had said, one of the very first human rights cases, you need to use the criminal law rather than common law, so that it's got Parliament's weighed up the balance, and Parliament's it's clear what the position is. So, and certainly one of the cases that was on there, the Canada Goose case, that's what the Court of Appeal had said. Why is it that the civil law is not the right jurisdiction in which to effectively create new public order offences? And one of the important things about a civil injunction is that it doesn't only prohibit conduct that is criminal, it goes wider, and it's able to restrict activity that's otherwise entirely lawful. So that has been a big tension. And the case that went to the Supreme Court deprecated the position that the Court of Appeal had taken about saying this is not really an area in which the civil court should be intervening. And so that whole idea that you would only really use civil proceedings where the criminal law is failing has not succeeded in limiting their use. And ultimately, they do have utility, because the thing about the criminal law is that you can have conspiracy charges, obviously, but you have to name an individual. You have to bring a case against an individual. And you can only deal with that person at that time. And obviously, if they're mass protests, then we've seen recently you can fill the prisons with large numbers of people if you want to do so. But that tends not to happen. Police do not go into protest and want to arrest everybody who's there protesting. So that's one of the benefits that they have of using the civil law is that, especially if you use persons on known injunctions, you don't have to bring a case against any person, and you can catch everybody, and you can therefore restrain wider conduct, not just criminal conduct, and you can cover large numbers of people who are then potentially affected, and it has a very big chilling effect.
It's a lot easier for the police to administer and use the public order offences and the inchoate offences
Yeah.
So the police are churning them through, that's how it seems. So
Maybe that's happening at the same time.
that's the case that are coming
Well,
up.
I think it might be actually they're going to run in parallel because they do have other kinds of benefits, and we'll have to see where we end up. But at the moment, from the cases that are coming through the High Court and the Chancery Division, there's a very large number of them.
Very quickly, I think the gentleman with the yellow shirt, and then Henry.
Yeah, I'm here from Unite the Union, and there was quite an attempt by the last Tory government to introduce legislation against a strategy our union's used in particular called leverage, which is about pressurising key players in a decision. And there was a lot of stuff in the Tory press about bringing in a criminal offence of using leverage against a company that you had a dispute with. The failure to do that might have motivated some companies to look more towards the civil side of things. A little comment really, I was very disappointed actually with the reaction to the counter protests over the sort of racist riots, and I felt that there was very, very little championing of the sort of public collective response, which was for me, I went to the one in Brighton, was the most fantastic response from people who were saying no to that stuff. And I think, you know, it is important that we champion collectivity and protest and defend it, because, you know, unfortunately, even the current government seemed to think that the only answer to the problem was to lock the people up. Whereas what we really needed was more of a social response, I think.
Yeah, just very briefly, I mean, just to add to Stephanie's point, I'm a criminal practitioner at the court. I mean, the reality is the high point of the right to protest law was Ziegler, and Ziegler has just been eroded ever since. I mean, you know, be careful what I say, but in a way in which the courts used reasoning which was questionable, shall I say? But it means, and the whole purpose of it is to prevent defendants being able to argue their case in front of juries, and they've been quite open about it. They've put it right down. So even without new legislation, courts have been moving in that direction. It's virtually impossible to get your case before a jury, and we then have the grotesque spectacle, like Trudy Porter, having proceedings taken against them simply for protesting about the fact that juries aren't being allowed to hear the arguments. So it's all a bit depressing, frankly.
Although she were.
She did, yes, although that's been challenged as well.
Just one comment on what you've said about pressure that you might bring to bear. That was very much a focus of the INEOS injunction, and they tried to use economic torts, so conspiracy to cause damage, economic damage, which are complex torts when they're applied in a commercial context, but then to try and apply them in a context of protest. It was essentially, if you were involved in any kind of activity, writing letters, organising a protest, campaigns and social media about, for example, the supply chain to the fracking companies, and you were seeking to get them to desist in facilitating the fracking, they sought to cover that through the injunction, and that was one of the controversial areas that they failed in, and they weren't able to use those torts. But the interesting thing about that is, if you put that in its historical context, what does that actually mean? That means you can't have sugar boycotts that might help to contribute to the end of slavery. You can't have boycotts of Barclays because it might end in apartheid, and you can't have boycotts of Israeli goods because it might have an impact on the genocide that's taking place in Gaza at the moment. So it sounds like that's like, so it's sort of, if you bring it back to what does that actually mean, it is a very substantial impact on effective protests that has had historically a contribution to significant change and progress in the world. So it is, and that is something that is very difficult for them to deal with through the criminal law, which is why they resorted to the civil court. And I think that part of it hasn't yet finished.
Thank you very much. We'll leave it there. Please stay and have some refreshments and continue the conversations with us, those that are able to, and look to see you downstairs for a drink and a bite to eat.